The time is now 8:14. Welcome back. The Supreme Court says they won't intervene in a discrimination lawsuit led by former head coach of the Miami Dolphins, Brian Flores. Flores sued the NFL and 3 teams back in 2022, alleging the league was, quote, rife with racism regarding its hiring practices when it comes to black coaches. He was later joined in the lawsuit by fellow black coaches Steve Wilkes, who worked here with the Panthers, and Ray Horton.
All right, so joining us now is our chief legal analyst, Kali Frode. So this is a win for Brian Flores and everyone who has joined this suit. The case can move forward, and more importantly, they can subpoena a lot of documents from the NFL, right?
They can. I mean, looking at the Supreme Court aspect of it in terms of the Supreme Court deciding not to grant cert and intervene, we talk about it here a number of times, 7,000 to 8,000 plus cases a year. You're talking about maybe 1% that they are granting access to hear. You need 4 votes. They didn't have 4 votes. You know that one person wanted to move forward with this case, Justice Kavanaugh. He dissented. He said that he would have liked to have heard this case. And so you know that there were at least 1, not 4. Moving forward with this case, I mean, there's a strong likelihood that they will be successful in this claim. They, as in terms of Flores. And I say that for a number of reasons. For them to be able to make it this far in this case already is hard enough. To make it past motion for summary judgment, to survive all of these motions to dismiss that they've done so far, 70, 80% of cases don't make it past that point. And so for them to make it this far, they need to be able to prove in what they've alleged is a number of things, but the biggest thing they've alleged is a violation of USC 1981. That's basically saying that if you discriminate against someone based on race regarding making performance, modification, or termination of contracts in an employment status, then that's a violation of that statute, and then they should be compensated. That is the argument that they're making here. West Charlotte's own Steve Wilkes is a part of this claim. I believe that they have the legs for this to go forward because they've already proven that they can defend a number of things where cases would fail.
If you were the defense attorney in this case for Flores and the others, obviously you've told us before you don't ever go to trial until you have all the facts ready to go. You like to know the answers, right, to all the questions coming up. What type of evidence would Flores and Wilkes and others need to have to prove the discrimination? Texts, recordings?
You're all over it. And it's not that you go when you know everything,
right?
But you want to know something. You don't want to file a claim because obviously that would be a violation of the rules of professional conduct to file a frivolous claim. But you want to ensure that, hey, we got them. We know what we're looking for. And then, as you mentioned, now I have access to the documents during the discovery process. I can get these documents to connect what I believe are 2 dots that will now show that we have a case. So what am I looking for? Emails, internal text messages, interview timelines, candidate scoring sheets. Remember in one scenario, the coach called him and said, hey, congratulations on you getting the job. And he hadn't even had his interview yet, and they had already decided to give it to someone else. Those are the types of things when you know, hey, I'm scheduled to have this interview, but I'm only getting this interview so they can do it from a performance base. It's not really an actual shot for me to get this job because someone else has already been hired. Those are the types of things, well, you scheduled it on a Monday, but you hired this guy last Friday. I want to know that timeline because now that I can prove that I actually had no chance of getting this.
The details like that are going to be key in this case, and they seem pretty damning for the NFL. But is it still a David and Goliath situation, even though you have some well-respected coaches who have had a solid career so far? Is it still going to be hard to take on the NFL? Do they go to trial, or do they just kind of make this go away?
Well, I mean, this is, first of all, David versus Goliath is an understatement. I mean, you're going against a billion-dollar industry, and you have individuals that at some point the resources will run out for litigation. And so there's always that aspect. But their defense team, or I should say their team, is doing an excellent job in terms of plaintiffs, making sure that they attack each motion to dismiss that has been thrown against them. I have to overemphasize how important that is. Most cases die there. You try to state a claim. Other side's going to say, hey, you haven't connected your claim to the case law, and because of that, Your Honor, we need this to be dismissed. The NFL wasn't really asking for this to be dismissed. They were asking it to go through the arbitration process because now that's something that we can control. You don't want this to be in the open court process. Not saying they can't control it, but the court is under the judge's control. You have to meet with discovery timelines. You have to do what the judge is dictating you, and you can't say, all right, I just don't want to give you those documents. Now you're going to be required to turn that over. It's going to be what's called reciprocal discovery. You can ask for things, and I can ask for things. I'm looking for things like those emails, those text messages, those timelines. That's going to hurt your case. That's why you want an arbitration.
All right, we'll continue to be following this case for sure, as we have been for years. Khalif, thank you very much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.